Madam Chair, I'm not sure if you can hear me, but I believe that the CLERB, that it's muted. I can't hear anything of the proceedings. And according to the screen, it says that the proceedings are muted for the recording or for virtual.
Can you hear us now?
Now I can, yes.
Great. Would you like to make a statement, please?
Yes, I am participating remotely because I am recovering from COVID, but I am here and present and will have my camera on throughout the proceedings.
Great, thank you. Hey, if we could have roll call, please.
Eileen Delaney.
Here.
Ms. Mary Ann Pintar.
Present.
Pastor Robert Spriggs Jr. is present. Andrew Hayes.
Present.
Dr. Arlie Brown.
And he is in traffic.
Thank you. Nadia Keene Ayub.
Present.
Thank you. Bonnie Kink.
Here.
Ariana Federico Mondragon.
Here.
Thank you. Tim Ware. G.I. Wilson.
Here.
That concludes attendance.
And we have a quorum.
Madam Chair, if I could jump in for just 1 second.
Yes.
Madam Vice Chair, if you could confirm whether or not there's anybody over the age of 18 at your meeting location.
Sorry, I forgot about that. There is no one over the age of 18 at my meeting location.
Thank you.
Thank you. Okay, next is public comments. This is opportunity of members of the public to address the board on any subject within our jurisdiction, but not on today's agenda. Each speaker should fill out a speaker slip, and you will have 3 minutes. And if we don't have anyone here in person, do we? Could you fill out a slip and then we will get back to you? Thank you. Do we have anyone virtually? Okay, we have no speakers. Okay. Mr. Parker, while we're waiting for that gentleman to fill out his slip, would you like to read into the record some that you have?
I would. The first request to be read into the record is from Deidre McLeod. Ms. McLeod states, "My name is Deidre McLeod and I'm a constituent of Supervisor Joel Anderson, District 2. My pronouns are she, her. The March 21st presentation by Assistant Sheriff Adams Hydar was welcome, but I would like to remind CLERB members that any San Diego Sheriff's Department effort to build transparency and trust would not be happening without intense public pressure by the state of California, media watchdogs, community groups and leaders, formerly incarcerated persons willing to share their lived experience, family members who have lost loved ones in our jails, and the CLERB itself. Transparency does not mean only what the Sheriff's Department is willing to share with the public, and trust is not earned by doing the bare minimum. Presentations and proposed pilot programs aside, I urge CLERB to continue to hold Sheriff Martinez to account for not adopting your recommendations regarding the booking and housing of transgender people and for reversing her election promise to release full internal incident review findings. Thank you. I have 2 additional requests for public comment. Okay. This is from Jeff Quirk. I thank you for taking the time to look into this matter, which is, I believe it's case number 22-102. This senseless ongoing harassment went on over 2 years by a subordinate officer who was enabled by the San Diego County Probation Department. This issue was addressed multiple times with upper management and brought forth to executive management. Being focused on budgets, wokeness, and politics, the malfeasance rested with those who chose to skirt their responsibilities and force multiple officers to endure this unwanted illegal harassment. Rather than allocating funds to county council and ultimately preparing a warrant to reveal via third-party vendor who this individual was, the department failed to act and forced undue duress on its people, which sadly continues to this day. It is disappointing after 24 years of service to the county that I had to retire to get something done. Being a retired peace officer, I was thankfully blessed with the opportunity to gain the service and support of CLERB. The San Diego County Probation Department is in shambles with serious retention issues due to the lack of support of its people who make the department and the services they provide work. Understanding that sexual harassment, intimidation, stalking, telephonic harassment, and engaging in conduct unbecoming of a peace officer stands in sharp contrast to the mission of the County of San Diego. Policies and procedures need to be enacted to protect officers who are subjugated by its leadership team. They ignored my concerns and allowed this to happen, as I told them it would. Through no fault of my own, I was directed to conduct this investigation and did so in a professional manner. Based on this individual's long history of documented harassment, I demanded to have my name redacted for safety issues, as I and my fellow supervisors believe this person to be a threat. This did not happen, and the harassment commenced immediately once the investigation concluded. Retirement is a milestone and a joyous event. That, in my case, was shattered with disparaging sexual comments made about my wife. This should never be tolerated and promoted by management's transgressions. As for my beloved co-supervisor who I worked with for 20 years, the stress, emotional damage, and hostile working environment left non-visible scars that will never go away. I pray that they will diminish in time. Thank you for your time. Please do not allow this to be swept under the rug. I have one additional comment to be read into the record. This is from Monique Edison in reference to CLERB case number 22-103. Upon the probation department informing the subject officer of the CLERB complaint, she immediately went on medical leave and eventually retired in March of 2023, evading any true investigation into this matter. Although the subject reportedly could not be interviewed, I beg to question, could CLERB still have investigated to reveal the source of the harassing text messages being sent to myself and a former supervising probation officer, who also filed his CLERB complaint? The companies from which the phantom phone numbers were originated require a subpoena to obtain source information. Given the probation department was not willing to assist in obtaining a subpoena, my hope was that CLERB would offer due diligence to assist. At least with that information, further documentation could be shared with law enforcement should the harassment continue and even escalate to violence. The subject should not again, as in the past, be allowed to continue to harass others without any accountability. This has been the history of this former officer for years. I am requesting CLERB seek the information as to the source of the phantom phone numbers with each respective company. It is by the subject's deliberate anonymity and evading accountability that has negatively impacted the lives of so many. Frankly, her behavior is unstable and unpredictable, which has caused myself and so many others to feel unsafe. And that is the last request to speak I have to be read into the record.
Thank you. And did we have, okay.
We have David Settles, please.
Hello. So my name is David Settles. I'm the brother of Matthew Settles, who passed away this past August at George Bailey. I think I've told this story, but it's good to see you all in person today. But, my brother had schizophrenia since he was in college. He was a very smart, educated person. He had 2 degrees. He had a lot of good years, even though he was in the mental health. He had gotten out, was doing pretty good in boarding homes and such, spent a lot of time with my family. My kids were all a close family. My mom, my brother have also spoken up. Matthew got back into the system, was delusional at that time, trying to get stabilized. And he was very weak at that point. He had already lost 40 pounds from his weight. And there's a number of things that we just, do not know. It was very frustrating. He was down at the downtown jail. Why he was transferred to George Bailey at the time, we had no information. The entire month he was at George Bailey, we could get no information. My mom every day reached out to try to find any information on him, and we could not. Knowing the situation in the jails, what had happened, my mom says we knew it could be a death sentence, and it turned out it was. And Matthew should have never been there. He should have gotten the treatment when he was downtown. At least there's a psychiatric unit. So, what I'm here just voicing is, we do want the transparency. We want to know the decisions and what happened, why Matthew died, alone in solitary confinement. He really never should have been there. And so just voicing for all the transparency and the strengthening of what you do to help, prevent this, the entire system, mental health system, prevent this from happening. But the jails are not getting the treatment he needs. And it was a death sentence. It should not be. And so thank you for all you're doing here. And that's all I have. Thank you.
Thank you. And I'm sorry for your loss.
Thank you. Next up, Sabrina Weddle, please.
Hello, I'm Sabrina Weddle. A few of you guys do know me. I am Saxon Rodriguez's older sister. Saxon Rodriguez passed away July 20th, 2021 in San Diego County Jail. I want to say this is public comments, but I'm not 100% sure. You know, I'm always here to say that I would love for you guys to take into consideration that, you know, they need to definitely scan employees. I know you guys have heard of Joanna Segovia that was just arrested for basically dealing fentanyl nationwide at this point. And until then, until Kelly Martinez starts scanning her employees, I'm convinced that she's working with her. My brother got fentanyl inside of San Diego County Jail 4 days into his stay in there. He did not get his day in court. Today, Alan Rozeski had his day in court. He brought cocaine onto Vista Jail premises, and I just want to see change. There should be no drugs on jail property. If we're scanning the inmates, but not the deputies, and they're still getting fentanyl inside of the jails, there's a problem. You know, there's just a number of things, and here we are on a Tuesday again asking for change. So again, my name is Sabrina Weddle. My brother Saxon Rodriguez died July 20th, 2021 off of fentanyl.
Thank you, Sabrina.
Thank you. We have 3 online requests to speak.
Okay. Mr. Parker, will you, okay, Valerie? Okay, thank you, Val.
First up, we have Dr. Fishman. Dr. Fishman, are you there?
Yes, thank you.
Yes, your time starts now.
Thank you. Darwin Fishman, he, his, him, and I'm with the Racial Justice Coalition of San Diego. Come, you guys, spoken many times. I definitely want to also, well, let me start by thanking Sabrina and David for their testimony. It's so important to hear from impacted families and their experiences. And I hope what I wanted to comment on is your last meeting, special meeting, and to thank you for that. And also considering those proposals to strengthen and improve the civilian oversight, improve CLERB. And hopefully you're connecting the dots from the stories that the family members are sharing with you and those policies if you adopt them. So things like oversight, going beyond what you have now to include healthcare workers, both of the cases what described to you, those family members. If you had oversight, there's a level of accountability that would be added for the people that are in the jails that's not there now. And I just want to really emphasize that point. I was actually surprised by your response to the proposals for San Diegans for Justice, in that I'm hoping that there'll be a more open discussion about them. It felt like the reaction, and I hope this is incorrect, was that these were radical proposals and that many of you were not comfortable with adopting them. And I'm hoping that in a public setting that you guys can discuss it openly. If there really are concerns with some or all of them, that you get that out there in a public way. It was very hard to figure that out. I would also, as a team member of this, to support your work, I would certainly offer, and we've done this before with the Racial Justice Coalition, helping to have a town hall so you can have a public forum, educate people about your work, help educate them about the proposals from San Diegans for Justice, and obviously they would be more than willing to co-sponsor with you some type of public forum and have an open discussion about those proposals, what they would mean, what the changes would imply, and also allow members to chime in about their support. It's very hard with this format, the public speaking part, the 3 minutes, and then the time that you have to respond to get a sense of that. What you are getting is a steady drumbeat, continue to get, of impacted family members coming to you and still not having questions answered, still feeling like that their relatives died, was unnecessary, not explained to them, and also feeling like last resort, and you know this, there's lots of lawsuits, millions of dollars being paid out. There's a lot of better way to deal with this, with people being held in custody and how they're treated. And accountability with civilian oversight is a really key part in helping to get us on track and making a correction. Thank you.
Thank you. Next up, we have Yusuf Miller. Yusuf, are you there?
Yes, I am.
Your time starts now.
Yusef Miller, North County Equity and Justice Coalition, Saving Lives in Custody campaign. I want to thank you for the families who have come out and represented their loved ones and asking for change. One of the things that I really wanted to ask in this public comment part is if you could share with us in an act of transparency, what is the rules and regulations when it comes to deputy versus medical staff when it comes to making medical decisions. And we would like to see that in policy in black and white. I know it's easy to just say, oh, well, a medical decision, the medical people are responsible. And in the place of safety, deputies are responsible. But we would like to see it in black and white. We are beyond the era of listening to what people say. We want to see it in black and white and determine if this is the best fit for whatever it is that comes out of this transparency. So the relationship between law enforcement decision making and medical staff decision making is something that needs to be transparent, especially given the cases that you're hearing coming before you, and those who couldn't make it today have the same concern. So I would like to thank you for that, and I'll be speaking to you again soon. Thank you.
Thank you. Next up, we have Leslie Crawford. Leslie, are you there?
I think I am. Yes, thank you.
Thank you. Your
you-
time starts now.
I didn't intend to speak, but David Suttles, I would like to be in support of him. My son died a month and a half, maybe after his brother in the same institution. And I thought my son was in 1A, which was mental health, but obviously he wasn't safe there. So I just want to say that this is not a case, a standalone case with Mr. Suttles. We are all suffering and we don't have any information. The investigators for my son case have not even had the autopsy returned to them, and that was 6 months ago. So, like I say, I didn't intend to speak, but this is something that is so important. I probably wouldn't be involved here if it wasn't North County Equity and Justice, but there's so many people suffering. I will not get my son back, but what you are doing is so very, very important to us. It's like living in a nightmare. So that's all I have to say. Thank you for being there and keep going. I'm good.
Thank you. Next up, Gilbert Gills. Are you there?
This is Gilbert Gill's daughter, Jennifer Schmidt. Can you hear me?
Yes, we can. Your time starts now.
My family called 911 for ambulance, and the police showed up, arrested him when he was having a mental breakdown, dementia, and they put him in jail where they neglected him for 15 and a half hours when they found him dead on the floor of the Vista jail. And the medical staff don't want to be watched by CLERB or under you guys' supervision. That's because they're doing something wrong. So we need to keep pushing forward to get over the medical staff in all of the jails. Thank you.
Thank you.
So medical.
That's it.
Thank you. And thank you everyone for speaking. Next is the minutes approval from March 21st. Are there any revisions? Does somebody want to make a motion to approve? Okay, so Bonnie, Mr. Brown, second. Okay. All those in favor, please do roll call.
Sorry. Eileen Delaney,
Yes.
Marianne Pintar,
Yes.
Pastor Robert Spriggs Jr., yes. Andrew Hayes,
Yes.
Dr. Arlie Brown,
Yes.
Nadia King Ayub,
Yes.
Bonnie Kink,
Yes.
Ariana Federico Mondragon,
Yes.
Tim Ware, is not here, and G.I. Wilson.
Yes.
Thank you.
Okay, motion carries. And now March 28th, any revisions? I do have one. You made it already? Okay, just that The board requested that Mr. Hayes and Ms. Kank meet with Mr. Parker to determine which types of cases would qualify. Do we have any other revisions? If not, is there a motion? Ms. Kank, second by G.I. Wilson. Okay, roll call, please.
Eileen Delaney,
Yes.
Mary Ann Pintar,
Yes,
Pastor Robert Sweet Jr., yes, Andrew Hayes,
Yes.
Dr. Arlie Brown, Nadia Keene Ayub,
Yes.
Bonnie Kink,
Yes.
Ariana Federico Mondragon,
Yes.
and G.I. Wilson.
Yes.
Thank you.
Okay. We do not have any presentations or training this evening, so we'll go right to the executive officer's report.
Thank you, Chair Delaney. Supervising Special Investigator Lynn Setzer and I met with the new Division of Inspectional Services Lieutenant David Perkins. We met with him yesterday. He'll have an opportunity later in the meeting to introduce himself. He's getting his feet under him as the new DIS lieutenant. He's aware of the pending policy recommendation responses and will ensure a timely response as he gets up to speed and continues to work with Sergeant Tingley. As far as the investigative workload and classification report for March of 2023, which is attachment B, you have the handout. Basically, there were 11 new cases. At the end of the month, there were 32 open cases involving deaths. We have one death investigation on tonight's closed session agenda. There are 9 open uses of force resulting in great bodily injury. We have 2 of those investigations on tonight's closed session agenda. There are 5 open discharges of firearms. We received 1 last month. We have none of those on tonight's agenda. And as far as attachment C, if anybody has any questions about that, that's just our way to make sure that the board members and the public know where we are with our case investigations so that we don't ever run into the problem we had, 6 years ago. As far as the correspondence that I sent to the full CLERB, I sent 4 emails to the CLERB containing 16 total media articles, which are also on our website. Now, we have a media section on our website that links every article I sent to this CLERB board on there. For the public to see. And so everyone knows exactly when we're referenced and whatnot. And as far as we have 10 outstanding policy recommendation responses from the Sheriff's Department that they're working on. We have none to present tonight. We have 4 from the Probation Department that I know that they're working on. We have none to present tonight. And for the most part, that's the extent of my executive officer report pending any questions.
Thank you, Mr. Parker. Do you want to talk about the sustained findings at all?
We have a couple of pending responses that the Sheriff's Department doesn't have yet, but we have no responses from them yet for obvious reasons.
Great, thank you. All right, as far as my chair report, I'd like to thank the public again for coming and speaking and letting us know your feelings. Board, thank you for your hard work. Staff, want to appreciate that. I also want to just mention that our meeting dates are not firm like they have been in the past, the second Tuesday, and that's because the Board of Supervisors meetings also use this room and they have been quite lengthy. So we have planned our meetings on the dates that the supervisors don't meet. And that's why it may not be on the second Tuesday. This was something I think we discussed several months ago.
This board have approved the
Right.
schedule in August of last year for the 2023 meetings.
If anyone needs to see our meeting dates, they are on our website. And with that, we'll go to new business. Mr. Parker?
Thank you, Chair Delaney. I wanted to take a few moments and only a few moments to really, I think one of the members of our board, I think it was Vice Chair Pintar last month, asked if I could maybe give a little bit of an overview about the current policing bills that are going forward up in Sacramento right now. Again, none of these bills have been approved, but I just want to give an overview of the ones that we've kind of keeping an eye on. Okay, so the first one, if I may, is Assembly Bill 742. Assembly Bill 742 specifically deals with police canines. And basically the rationale and the reason for the bill is that obviously canines themselves can't meaningfully de-escalate. There's a history of racial disparities, and there's the racist history of canine usage in law enforcement going back decades. So that's the reason that this bill has been put forth. And what the bill what the bill wants to prohibit is the use of unleashed canines, unleashed canines for arrest and apprehension. It would want to prohibit the use of canines for crowd control and to prohibit canines from biting in any circumstance. It would allow for canines to be used for search and rescue, explosions and narcotics detection and whatnot. So that's AB 742, working its way through in Sacramento right now. There is a bill now. Actually, there's a concept about record access. The grand jury, the DA, and Attorney General, they aren't barred from obtaining confidential personnel information as outlined in Penal Code 832.7, but we are. Civilian oversight entities are, unless, of course, there's an MOU between that respective jurisdiction and the civilian oversight entity. This bill has not been yet presented. We don't know the bill number yet, but it talks about adding civilian oversight agencies to that list of organizations that wouldn't be barred from obtaining that information. So I'll keep you in the loop on that if that makes its way forward. SB 50, and this is going to sound a little bit, the concept of this should sound familiar to everybody on this board right now, because a year and a half ago, we made recommendations to the Sheriff's Department based on the town hall that we have for racially disparate policing practices to prohibit or to reduce or eliminate offenses, to be contacting folks for low-level offenses. SB 50 provides that law enforcement shall not stop or detain anyone for low-level traffic offenses. Instead, would rely upon the mailing of citations, which is exactly what we had proposed last year. It also would authorize non-peace officers to be used for traffic enforcement, to take away law enforcement peace officers from doing that. Now, this is SB 50, and again, none of this is passed yet, but we're keeping a close eye on that as it makes its way through. Assembly Bill 807, I think everybody in the room is familiar with Assembly Bill 1506 from 2020 that allows the California Department of Justice to investigate the police shootings of unarmed persons. AB 807, there's some confusion about what's armed and what's not. And, sometimes, what really is going on, right? So this AB 807 would expand to all incidents where use of force results in a civilian death. It would expand to allow the California Department of Justice to investigate those deaths as well, not just those who are armed. AB 797, and I hope I don't have to turn this over to council to make sure I'm on the right track here. But so AB 797 is very interesting. It is proposing that an independent community-based commission on law enforcement officer practices be created for every municipality and county that has law enforcement services. That's my understanding. So it's a community-based commission on law enforcement practices. What the bill says is that that commission would have an independent counsel, but we don't necessarily know the definition of that. It would also have the Board of Supervisors appoint an executive officer, appoint independent staff to look at allegations of the use of force resulting in injury. That's the extent of it as it's written right now. So we're a little, we don't know where that's going to go. We don't know if that means anything for us because we currently exist and we obviously have much greater jurisdiction than what that is proposing. So we really don't know, but we're definitely keeping an eye on AB 797. Interestingly enough, AB 360, I think, again, maybe everybody in this room has heard the term excited delirium. It's kind of been the hot topic term for the last couple of years in medical legal death investigation and law enforcement related deaths. This bill, AB 360, would prohibit the use of the term excited delirium on a death certificate. And they say that term is not a valid medical diagnosis. So that's AB 360. Finally, well, I think that's really it right now, unless anybody has any questions for me.
Members of the public, do you have any questions? Okay.
Yes. Yusuf Miller, are you there?
Yes, I am.
Yes, your 3 minutes start now.
Okay, Yusuf Miller, North County Equity and Justice Coalition, and the Save Lives in Custody campaign. I would like to see on your radar AB 268, which is the new number for AB 2343, the Saving Life in Custody Act. That is by Dr. Akila Weber. Also, AB 1584, which is the dealing with mental health, particularly in the jails. So those two are currently in the works. So no, they're not approved yet, but please put that on your radar, those two on your radar.
That is it. Thank
Okay,
you.
thank you. Anyone else?
May I, Chair
Yes.
Delaney? Thank you to Mr. Miller for that. That will now be on my radar, and I'll report back perhaps next month with an update on AB 268 and AB 1584. We'll keep an eye on that. Thank you.
Is the board able to make a stance supporting a bill?
Council?
Clerk could, as a board, vote to support or oppose the bill. I'm checking. I don't think you can do it tonight under the current agenda listing.
We'd have to agendize it at a future meeting. If you're interested in that, please contact Mr. Parker and talk about that. Okay, thank you. All right, we'll now go to unfinished business. So this is the updated proposed revisions to CLERB's rules and regulations. And if you remember from our last meeting, we had asked Mr. Hayes, sorry about that, and Ms. Kank. Yeah. And Ms. Kank to meet with Mr. Parker and to discuss which cases might be exempt from the year filing. So I'm going to turn it over to Mr. Hayes and Ms. Kank.
Thank you, Madam Chair. So we met with Mr. Parker and we went through, the proposed revisions to the year. And we set some parameters and we talked about what those parameters were, with the goal being that we put those in a letter to us all so that we could then read the parameters by which we would not, we'd go back and look into a case a year, over that year limit that exists. And so we came up with, there was numerous different ones, and we kind of mirrored Penal Code section 832.7 in that. So that was kind of the discussion we had. And then, we had some discussion about it. And I think we came to the conclusion that we wanted to bring it back to you all for your input to hear, what you think, if we should accept all of these, some of these, one of these, two of these, three of these, whatever that may be, and then kind of cap it and move on tonight with this item. So, I have some additional thoughts since our meeting and just kind of my perspective on what I believe we should move forward with. But I want to make sure Ms. Kank has the opportunity to share from the meeting as well.
I think you said it all. Thank you.
Well, I'm happy to share what I think that we should do.
And also,
I'll explain. Yep. So my perspective on this is that on our letter that we have received from Mr. Parker, we have, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9 different reasons. I would say that A, B, C, D, E, and the last one, in addition, I propose there should be no 1-year time limit for receipts of complaints involving allegations of great bodily injury arising out of or in connection with actions of a peace officer or a custodial officer. So of those 9, 6, I propose that we move forward. And F, G, and H, the number one challenge that I have with them is that while laudable, I believe they'll expand the workload of staff that I don't think we're able to take on at this time. That doesn't mean it can't be revisited later. I just perceive that they're written in a way that, someone can make an allegation from 20 years ago that they remember. And, we then have to proceed with records that we may or may not have. And there may just be concerns that those are some of my concerns. And so then staff is taking time to go and look into those allegations while we have other allegations that are being made and other cases that are before us that they need to look into within that timeline of a year, right? So that we don't get backlogged. So those are some of my concerns. But I think, A through E and then great bodily injury, no 1 year time limit to the great bodily injury complaints, I think are important. So that's my perspective here.
Okay, and for the benefit of the public, if you could read those, but prior to doing that, I just wanted to say that Mr. Parker and Vice Chair Pintar and I discussed this, and we think that whatever we decide would be exempt would be for a 3-year period, 5-year period, if it's something that new information has arisen. So go ahead and share with the public then, if you would, the A through
Yep.
A
So
through.
So the ones that I propose we move forward with then are A, an incident involving the discharge of a firearm at a person by a peace officer or custodial officer. An incident involving the use of force against a person by a peace officer or custodial officer that resulted in death or in great bodily injury. An allegation of unreasonable or excessive force by a peace officer or custodial officer. An allegation that a peace officer or custodial officer failed to intervene against another officer using unreasonable or excessive force. E, an allegation that a peace officer or custodial officer engaged in sexual assault involving a member of the public. And then 1 and 2 under that, they define sexual assault and what member of public is. And then the last is there should be no 1 year time limit for receipt of complaints involving allegations of great bodily injury arising out of or in connection with actions of a peace officer or custodial officer. Those are the proposed.
Thank you. Also, go ahead and read the ones that
The
you
ones
think.
that not, okay.
Yeah, let's, so that everyone can hear
So
them.
F is an allegation of dishonesty by a peace officer or custodial officer directly relating to the reporting, investigation, or prosecution of a crime, or directly relating to the reporting of or investigation of misconduct by another peace officer or custodial officer, including but not limited to any false statements, filing false reports, destruction, falsifying, or concealing of evidence or perjury. G, an allegation that a peace officer or custodial officer engaged in conduct, including but not limited to verbal statements, writings, online posts, recordings, and gestures involving prejudice or discrimination against a person on the basis of race, religious creed, color, national origin, ancestry, physical disability, medical condition, genetic information, marital status, sex, gender identity, gender expression, age, sexual orientation, or military and veteran status. H, an allegation that a peace officer or custodial officer made an unlawful arrest or conducted an unlawful search.
Thank you. All right, members of the public, do you have any comments?
Chair Delaney, I have one request to be read into the
Of course.
record. My name is Deidre McLeod, and I'm a constituent of Supervisor Joel Anderson, District 2. My pronouns are she, her. I'm confused and disappointed by CLERB's decision to prioritize only some of the 21 rules and recommendation changes asked for by executive staff and supported by the public. Based upon the categories you divided them into, is your intent to send repeated proposals to the County Board of Supervisors, engage in multiple rounds of meet and confer with relevant unions, put more than one ordinance change before the people of San Diego for wanting to be deliberate with your actions. But all 21 changes were right there in a redlined copy of rules and regulations on March 28th. They were ready to go. All prioritization appears to do is add months of delay to a process that needs to have been done yesterday. If you disagree with any of the proposed changes, discuss them on the record, but otherwise this entire package should have been passed. I urge you to move forward expeditiously with the process of strengthening CLERB's oversight responsibilities, not just with all original 21 changes, but with the additional public supported recommendations from San Diegans for Justice. Thank you.
Thank you.
We have 2
Okay.
online. Yes. Mr.
We are discussing tonight that is on the agenda.
Can you hear me?
Yes, we can hear you. Your time starts now.
Okay, Yusef Miller, North County Equity and Justice Coalition. And I agree that we should move forward with the recommendations from San Diegans for Justice. I know you want to take, manageable pieces and manageable bites, but this is a really critical review. And I think that since it seems to have overwhelming support, that we should move forward and get it to the Board of Supervisors as a complete package and move on it. The items that were not accepted for this particular go round seems like it had a lot of the terms and categories that fall under protected class, and we're not going to look at those. I mean, though, or at this moment, no, those should be looked at immediately when it comes to persons' race or religion or gender identity and things of that nature. So I'm frustrated with the fact that this package may be delayed over periods and broken down into parcels, and may we move forward in this very well done, very comprehensive, and very easy to not easy to digest, but easy to accept. I believe that there are some revisions that need to go with the CLERB's rules and regulations. Thank you.
Thank you. Next up, we have Robin Sales. Are you there?
Yes, thank you. Good evening, CLERB members and Mr. Parker. I'm Robin Sales, showing up for Racial Justice North County. I'm very appreciative of your reception of the Sandinians for Justice proposed ordinance at the special meeting on 3/28. I am not in support of your measured approach and prioritization, and must express my concern that you left out the most important piece, which expands the type of oversight board that San Diegans deserve. Without the capacity for, quote, auditing, monitoring, and conducting analysis of policies and patterns in practice, as stated in Mr. Parker's letter, the CLERB will continue to be hamstrung in getting to the truth of what occurs at the sheriff's internal investigations, and this engenders a lack of trust in the community. In light of the fact that no deputies have been indicted in conjunction with in-custody deaths, I find it very hard not to suspect that the CLERB is missing very vital information that could inform your recommendations and the DA's. Please continue the push to give your oversight teeth, with the overarching goal of providing families with the truth and accountability they need to have some peace of mind that justice has been served. Thank you.
Thank you. We have no more requests to speak.
Okay, thank you. Mr. Parker, if you could reiterate.
Sorry,
Oh,
we have one.
okay, sure.
Hello. I just wanted to state, as far as the 1-year limit, I know that you talked about the 3-year and the 5-year limit. And I just want to say that would be appreciated to families like ours, where it takes about 6 months to 7 months to get an autopsy report. Like I stated, the first meeting in person, I barely got the sheriff's report, where I actually got to know who was in charge of my brother at the time he died. And again, I'll say those names: Brian Powell, Andrew Randovich, Maxwell Rimple, Andre Wanzer. Those were the deputies. The nurses were Melissa Burns, Reggie Barreto, Carrie Cavello, Ria Encarnacion, Caitlin Hendricks, Marilyn Ibanez, Kelly Payne, Levy Santos, and Chantel Williams, none of which were held accountable for the death of my brother. All got to clock in the next day. And again, when it comes to the reports and the complaints that it takes up to 6 months to even know why my brother died. We knew he died off fentanyl, but we didn't know that he wasn't checked in the he intook those drugs. Nobody forced those drugs in his mouth, in his nose, but he received those drugs in a facility that is guarded, where, again, the inmates are scanned. My brother was scanned. The inmates that I listed right there were not scanned that day, nor the day after. The nurses were not scanned. They got to clock in the next day, yet we have a time period as to when we can file a complaint. I don't see where that's fair. I have a dead brother and they have a 6-figure job. They can let anyone die. They get to clock in the next day. I've seen several members of the CLERB walk out during these meetings when these family members are speaking. Do we care or do we not? Because again, everybody's here paid, but the family members who have a dead brother. I brought my blanket today, so because I don't know if it's going to be hot or cold in here, but I don't have this person on this blanket anymore. And nobody was held accountable for his death. Yes, he did the drug. How did he get the drug? Because he died in 2021 when there's no visitors. So again, the 1-year time that we have to file a complaint or anything, that usually gets retaliated with, oh, if you sue us, we'll sue you when we win. So how can a poor family do that? Couldn't even afford the funeral. So again, the 1-year time limit needs to be expanded. We're not asking for 20 years, but I know we would love to cap and seal it and end it here because nobody would get held accountable, right? Thank you.
Thank you.
Thank you.
Mr. Parker?
We,
No,
sorry, Chair, we have one more request to
Oh.
speak online.
Sure.
Yes. Leslie Crawford, are you there?
Yes, I'm here. Thank you.
Hi,
Okay,
starts now.
you have just heard from someone who is still bleeding after years, okay? Because she listed personnel, but I really see the problem as above the personnel. I see the problem in management. People who are down below, they do what their bosses tell them to do. The policies and procedures of the sheriff department are clearly lacking. And like I mentioned earlier, I will never see an autopsy report. The investigating Detective Snow said he hasn't seen it because he's still investigating. That was last fall. But instead of getting to the nitty gritty of the little, well, I won't say little, of people underneath management, the problem is always procedures and policies dictated by management. And I hope CLERB will focus towards that. Thank you. I'm so sorry. I'm through.
Thank you. Chair, we have no more requests to speak.
Okay, thank you. So I'd like Mr. Parker to just go over what we did approve last meeting.
Thank you, Chair Delaney. On the March 28th meeting, just for everyone to be clear, what this board elected to move forward with, we put forward 21 recommendations in addition to, many of those came from the San Diegans for Justice report. Some did not, but many did. And this board has wanted to move forward in the past with 68 out of the 70. But to be clear, many of those, and I'll get into some of them in a minute, many of those proposed recommendations do not need a rules and regulations change. It's something that I could institute if it's something about our internal procedures, about how we investigate, or what we look at as far as documentation required or whatnot, right? So, and I'm obviously prepared to come back maybe at next month's meeting and tell you all the ones that we're going to implement internally with staff. But the major ones that have been discussed, there were this CLERB grouped them into 3 categories. One was to codify the current practices. So 9 of the recommendations out of the 21, 9 were simply to make it put in writing what we're currently doing. And 2 of those came from the state audit that the Sheriff's Department and CLERB underwent last year. So that was group number 1, 9 of them to codify current practices. Number 2 was to expand CLERB's jurisdiction, to pursue the expansion of CLERB's jurisdiction to include medical service providers. Out of the 21 recommendations, 6 were included in this category. So far out of the 21, we have 15 that this board has approved for me to begin to move forward with. It should be noted that yesterday, myself, Chair Delaney, Crystal Irving, the president of SEIU, and David Lagstein, I believe, chief of staff at SEIU, responsible for the medical service providers, had an initial meeting. It's not meet and confer or anything like that. It was just for us to hear some concerns about this proposal that CLERB has approved me to move forward with, and we're going to move forward with.
Excuse me, Mr. Parker, could you explain who they are and not just their initials so that the public knows that they are the union? Yeah.
As she just said, they're the union responsible for the medical service providers that work in the jail. And so I know last month we had at least one member of one medical service provider show up on the 28th. And so there is obviously a concern that they have not been consulted with as we are making decisions to move forward to get jurisdiction over them. So we're still going to move forward and pursue that. But obviously over the next month or 2 or whatever it takes, however long it takes, I'll go anywhere. I will do. And to be clear, what we're simply trying to do when it comes to medical service providers is to get the full story, to get the full story. That's it. And many times, to be clear, I would imagine, I would certainly hope that many times we would say action justified. Medical service providers did what they were supposed to do, just like we do with deputies. Sometimes we're probably not going to be able to say that. We're going to be able to put out circumstances or whatnot. So these are the conversations we are willing to have, or we're going to move forward. I'm going to have that over the next however long it takes to make sure I hear everyone as we continue to move forward to implement these changes that CLERB wants me to move forward with, which we all want. So that's number 2. And the third and final was this elimination of the 1-year time limit. And out of the 21 recommendations that we made on the 28th, basically only one with 9 different parts is part Mr. Hayes just went over. Okay, so that's what we are moving forward with. That's the 3 categories. It turned out to be 16 different out of the 21. There were 5 that this board does not want to move forward with at this time. I've been assured by the members of this board, it doesn't mean they don't want to move forward with it at all. It simply means that they want to look at this for now. And then as far as audit, monitoring, pattern and practice, jurisdiction of all employees, things along those lines, which we have pushed for as well, that we take a little bit of time on that. Let's do this first and then go to this. That's what the board is directing, and that's what we're going to do unless the board tells me otherwise. Chair Delaney, does that answer the question?
It's good. Does anyone have any comments on that? Okay, so with that, I'd like to call for board.
Sorry, we have one more request to speak.
Okay.
Mr. Tom Packard, are you there?
Yeah, can you hear me?
Yes, we can. Your time starts now.
Yeah, thanks. I signed up, I think, to speak on item 8. I'm not sure if I'm in the right spot, but I wanted to comment on what you've just been talking about. Tom Packard, member showing up for racial justice, North County. I clearly support your moving forward with the recommendations. I appreciate the work you've done on this sorting. But having said that, I don't see a reason to delay submitting any of them like you're planning to hold back. At the special meeting I noted, I think they're all relevant, important, sensible, and feasible. As a former employee of both the city and county of San Diego, I have some insights about the dynamics when staff are given a lot of outside input, which they might see as unnecessary, not too important, or simply time consuming. You can dialogue with staff about priorities, importance, and then have them take it from there in terms of giving them all of the recommendations. Now you've had several months at least to work those things over. And then when you do that, please ask them to report at each meeting the status of each recommendation, including the ones that they haven't yet given attention to. And also, I noted a little bit last time, have them report barriers to implementation that they see so that the barriers can be resolved to ensure implementation. I hope the department's leadership has the skills and the wherewithal to involve relevant staff and employee organizations in analyzing the recommendations and detailing out implementation plans that are feasible and responsive. Each of the recommendations suggests clear and obvious benefits to the department and the people in the community being served. If staff are involved with implementation, the results should be of high quality and supported by those who will actually implement. I'm happy to hear that Paul Parker met with some of the employee representatives, and I think they ought to be looped in as much as possible. But I really hope you can get these things to the sheriff's department and let them get a timeline on how they're gonna they know which ones are the high priority ones, so I hope they can you can get them moving on those things. Thanks for your attention.
Thank you.
Thank you. Yeah, we have one more. Mr. Andy Trimlett.
Hi, thank you very much. I'm Andy Tremlett from Activate La Mesa. I just wanted to say I think it would be really valuable to take you up in your offer to list out which of the items will be handled by rules and which ones are going to be postponed, and a better understanding of why each of the ones that are going to be postponed or not taken up, I think would be really valuable in the interest of transparency, which was definitely one of the main values that was put forth in the last meeting. So thank you very much for your time.
Thank you. There are no more requests to speak.
Okay, thank you. Any members of the public? No? Okay, and we'll close that and we'll go to board. Anyone on the board?
I'm happy
Mr.
to
Hayes,
ask
okay.
a couple questions. So you had mentioned the 3-year, 5-year. What would that's going to apply to the 1-year policy that we were discussing?
That's correct.
Okay, and so are we defining that as where instead of 1 year, it's going to 3 years
That's correct.
or 5 years and that's
If that's what the board decides.
Got it.
Yes, it would be 3 years unless other information comes up afterwards, and then we could go to 5 years, depending on the nature of the, thank you,
so
nature of the case.
So should we clarify which one of those would be 3 year and 5 years? Or should we? I mean, this is a question to the board. I'm just asking,
Yeah.
should we
No, that's
define
good,
that?
and I
Or
appreciate
should
that.
we?
I think it was going to be in an umbrella, but let's talk about that.
Well, I guess my comment would be is, what we're functionally doing here with this 1 year is we're saying, look, there's not going to be a 1 year cap, anymore on when a complaint is filed and on these items. And then the ones that I thought,
Correct.
we should, remove, obviously we have to vote on it. So then let's say we were to say that we wanted a 3-year limit on the proposals in A, B, and C, and then for a 5-year on D and E. This is an example. I'm just giving you an example of, is that how we want to pursue it? Or would we rather say, we're just going to do 3 years for everything we approve tonight, or we're going to do 5 years for everything we approve tonight? So I just see 3 or 4 different directions we can go. And so I think we should talk about in transparent, we're open,
Absolutely.
we're talking about what the path would look like. So that's what I'm offering, just clarity on what folks would like to consider. I
So-
have some thoughts, but I've been talking a lot.
All right. So when Vice Chair Pintar and I discussed it, our thoughts were, and Vice Chair, are you there?
I'm here.
Our thoughts were that it would be 3 year would be the limit, and that would be for everything. And then if something, some information came, new information came forward and we needed to reopen a case or we need to look at something, then we would extend that to 5 years within that 5-year period if something came forward, new information came forward. Vice Chair Pintar, was that your understanding?
Yes, but I do understand why it might not be entirely clear. I think we thought 3 years seemed like a good amount of time to extend the time period for all of these cases. And then if new information became available, I don't know, a new witness came forward, there was additional information that would allow us to revisit a case that had extended beyond 3 years. That's sort of the line we were trying to distinguish. I'm just trying to keep this manageable for our investigators and allow them the time to focus on what is most important, which are most of the categories that we've described here in A through H. That's my thinking, at least.
Thank you, Vice Chair. Council, are we on the right track?
I don't see any legal issues with what's been
Okay.
proposed, and I can help draft up
Okay,
your board's direction.
thank you. All right. Any other discussion?
So then I guess my comment would be is now I understand the 3 year. And so I guess the question I would have, and Paul may have to talk to me about logistics, but if so, let's say we get more information. We determine that we reopen a case based on if it was open before, I would take it, right?
Are you talking about the?
Yeah. So let's say we got new information. So let's say tonight we say, 3 years. Okay, that's it. A through whatever,
A through H.
A through H. That's where it is. Let's say we do that. Then let's say, okay, we get new information. Under that new information, what are we considering new information to reopen the case, I guess is what I'm saying.
So to be clear, if I understand what you're asking, you're asking whether or not we've already looked at and investigated the case.
Yes.
If that's the case, then we would go with basically the information, the new information that comes, the same definitions as POVAR, reopening a case under the Peace Officer Procedural Bill of Rights, which is in our rules and regulations pretty much anyway. That there has to be new evidence that couldn't have otherwise been determined, and it may have may change the finding. At least that's what it says right now. I think we're in the process of changing that a little bit to conform with POVAR, but does that help a little bit?
Yeah, that's very helpful because that addresses some of my concerns from earlier with respect to timeline, right? Because some of my concerns were, case workload and everything else. But when you have because eliminating a 1 year with no other limitation is certainly is an impact logistically on staff. So that's helpful.
Madam Chair, may I? Don't know if you can see me.
Oh, Vice Chair, yes.
Sorry to interrupt you. I just wasn't sure if you were able to see mine. I think that one thing we should clarify per Mr. Hayes' comment is I don't believe we have that if there's new information, it doesn't only apply to a case that we've already examined within the 3-year period. It could be, in my view, it could be a case that we have not previously examined, but someone discovers something new. I don't know if they have like a later medical report or autopsy report or witness that comes forward. I was not thinking that it would have to be a case that we had previously reviewed. I just want to clarify if that's what others had in mind or not.
That's what I was, my exact thinking. Yes, we don't have to have previously reviewed the case for it to come to us and start the review.
Okay.
I'm with you on that.
I get it because that's the function of the 1 year time limit. I understand that. That's why I was asking it because I just wanted to make sure that that's how it applies. So that's very helpful.
Okay. Right. I'm just going to go around and we'll do it. Do you have any comments?
Sorry, Chair. Miriam Pintar has her hand up.
Sorry, just one other thing to clarify.
Yes.
Did we, and if it's in here and I missed it, I apologize, but did we also clarify whether, is there a time frame upon which this would be effective? I realize that all of these still have to go to the Board of Supervisors, and I'm not sure the public is completely clear on that even if we adopt these today, all of this has to be approved by the Board of Supervisors before they become effective, correct? So nothing could be effective, including the, I don't know, not the tolling, but the date upon which the cutoff time frame for bringing cases forward. Do we know, maybe council can answer that question? Is it from that date that it's approved by the Board of Supervisors forward? I don't know the answer.
That's an excellent point. We're going to need to look into the due process issues of having this apply retroactively to actions that took place before this was a rule.
Thank you. That's what I think. And we don't have an answer today. We should probably figure out the answer and clarify maybe by next month.
I think that would be part of when we do this, when the council writes this, that would be part of it. Ms. King.
I think it's important too for the public to understand that the Board of Supervisors does have to approve this. So in my opinion, we shouldn't overwhelm them. We should do the little steps that we've taken. I think that's really important. When I was on the grand jury, we had to have our county council approve our reports. And invariably they'd come back and say, you asked for this, 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 and this, and this. They will throw out the entire thing because of one of the requests. in a list of requests. They'll throw out the entire thing. So I think it's really important that we take step by step.
And that was one of the reasons why we did it. We want to make sure that they have their full attention on this. This is a priority. And then once this is in action, if you will, and been implemented, then we can move on to the next.
Right.
So, yeah. Ms. Kinayu. Okay. Mr. Wilson?
Yeah, I like the 3 and 5 year timeframe. I don't know if I have to think about making it ex post facto, how far we backdated. But in addition to that, I'd like to really ensure that when new information becomes available, whether that comes from the public or from one of our investigators or even a CLERB member, that we have the capability to look at that, because we've really been boxed in. But I'm in concert with Andrew. So,
Pastor Spriggs.
I'm kind of torn between the 3 year and the 5 year. I feel like we should just blanket everything under 5 years. So therefore, it won't be a back and forth. We do the 3 years. Oh, something comes up, then 5 years. I feel like we should just make it a 5 year thing, period.
Okay, thank you. Dr. Brown.
I agree with him. I agree with Pastor.
Okay. Yeah. Can you turn his mic off? Thank you. All right. Ms. Frederica Mondragon.
Is there a challenge having a 5 year? Can you share what the challenge would be having a 5 year versus a term that's 3 years and possibly opening up to a 5 year?
I think that's a great question. I think to your point, I think there are two challenges, right? Number one, it would increase the caseload. But quite frankly, I got to be honest with you, and I know I've heard that said here before, and I don't know if it's appropriate for me to say, I don't care, right? I think that we should have the cases that we should have. And then if we don't have enough staff, then we ask for more staff and we can justify it. That's number one. Number two, the farther back you go, right? The chance of people being still available to talk to, witnesses, evidence, reports, all those things might not be as great as if it was a shorter time period, but it would be a chance that we would take, and we would do everything we can to do our independent investigation based on the evidence that's available.
Okay. Andrew, anything else?
No, the only other thing is that if there's concerns about 3 year, 5 year, there's always the idea of saying, well, these are 5 years, these are 3 years. If these complaints were received based on these definitions here, 3 years is the cap, 5 years is the cap. We can always go two paths. It doesn't have to just be 1 3 year, 1 5 year. We could say A through E, for example, are 5. F and G and H are 3. So we can say those things if we so chose.
Gotcha.
Thank you. Okay. Council, can we separate them and do first vote on? Okay. All right. So
I'm sorry, Chair. We have a request to speak online.
May I take that?
And another one here.
Hang on.
They've spoken on this item.
Have they spoken on item 8 already?
No.
No.
I'll go ahead. We'll go ahead and let him. And just for the public, once we close public, it normally, once we start our discussion, there's no more public input, but I do want to hear what people have to say. So this one time we'll go ahead.
They put their hand out.
Oh, okay.
Online.
All right. All right. Thank you. Okay. So we're going to separate. So Andrew, if you could go ahead and I'm sorry.
I just need 30 seconds.
Come on up.
To follow up what Paul said, yes, we shouldn't care about the workload. The less lives that we save, you won't have as much case loads. And again, I've said it again, your guys' pay is really nice when it comes to investigating A, B, C, and D. To me, A, B, C, and D is Saxon, Elisa, Matthew. Elisa's case has been going on for about almost 4 years now, and they haven't even got their day in court. So when it comes to new evidence, let's look at Elisa Cerna's case. I can't say too much about it because it is an ongoing case, but that case has been going on for 4 years. And the only people we're charging is a nurse and a nurse and a doctor, and no deputies. So when it comes to, again, opening cases, closing cases, 4-year, 5-year, A, B, C, and D, I know, Haynes, you see it as A, B, C, but like I said, Saxon, Elisa, Matthew, these are names where they're not A, B, C, 1, 2, and 3. I know it's like project 1, 2, 3, 4, but these are our lives. Again, our siblings, our brothers, our sons, daughters, and you guys are putting a timeline on a life that got cut short. Half of these lives didn't get their day in court. So remember that when we're talking about having to put a timestamp on it. Yes, workloads. Half of us have to miss work to come here. You guys have to work to investigate our siblings, brothers, daughters' death. But once this change comes, hopefully we won't even have to keep adding to these people. So yes, you'll have to go back 5 years, but look, you won't have to investigate any new deaths that happened that year. Thank you.
Thank you.
Thank you. Chair, we have an update. We have 2 requests to speak online.
Have they spoken before on this?
No.
All right, we're going to take 2 and that is it. Okay. Okay.
Yes. We have Gilbert Gills. Are you there?
This is Gilbert Gill's daughter, Jennifer Schmidt. Can you hear me?
Yes, we can. Your time starts now.
What does it matter if it's 1 year, 3 years, 5 years, 10 years, if nothing is happening to these people you're investigating? What does any of it matter if you guys don't have the teeth to do anything to them? That's all I have to say. Thank you.
Thank you. We have Paloma. Are you there?
Yes, hello. Can you hear me?
Yes, your time starts now.
I thank you, the board, for letting me speak once again on this matter regarding the death of our loved one. I think it's not, Sabrina said it beautifully. I don't think it's right that there's a time limit that should be placed on this, because, even like with the audit that they did, they were able to conduct the audit with, I think, 185 deaths. But in reality, they weren't able to use a lot of the deaths that are in process of being investigated. Like Elisa's death was not even put into that audit. So I don't think it's right. I was very pleased with last time's meeting that we had together. We saw progress, but I don't think it's right that there's a time limit when even the sheriff's department is refusing to release names of all people who are involved in the deaths of my daughter and of other people. They're very slow. They're taking advantage and letting this statute of limitation, happen. So, people are being dropped off of civil cases and stuff like that because of this time limit. There's no time that would ever bring back my daughter. And I don't think it's right to set a time limit. It needs to be continued being investigated so we could get all the truth and justice that we need for our families to see the right thing to be done, to have everyone held accountable for her death and everybody else's death. I thank you.
Thank you. Chair, there are no more requests to speak.
Ms. Kinayu.
I have a question, and it's based off the public comment by the lady that was just here. My concern is that she stated that one of the cases went to 4 years. Is there a way to find out what the average time frame is in which these families are contacted and when they're given the information, and we can base our response or what we ask for based off that? Because if it is extending to 9, 12 months, then honestly, we should be asking for 5 years in order to verify all the information.
Thank you, Mr. Parker.
I think the only response I would have to that is the one of the main reasons that families, one of the main reasons that they don't know the cause or manner of death is because the medical examiner's office is not able to, they're getting better, but they're not able to give the cause and manner of death, within a certain couple of months. Sometimes it takes much longer lately for whatever reasons that they're addressing right now. So that would be number one. Number two, as far as information, my hope is that the family liaison program that the sheriff's department has and that we made a recommendation to strengthen, my hope is that program, that liaison, is keeping the family members in the loop as they move forward with the investigation. That's exactly what we've asked them to do. And we've also asked them to meet with the family at the conclusion of their investigation to give them the results and to give them the answers that they have not received. So I think as far as the timing this goes, I mean, that criminal investigation that the sheriff's department conducts could take upwards of a year, which we've seen. It could take even longer. But again, with the medical examiner delay, that's contributing big time as well. So I don't know if that answers a question other than give you the reasons for family members at least don't have a cause and manner of death.
What I'm interested in is if there is a average time frame on it, because from what we've seen from public comment is that it's a lengthy amount of time. And for me personally, just the idea that once you find out the manner of death of your loved one, it takes time to grieve, time to process, and then time to consider your options afterwards. So even 3 years, I think, is a shortened time frame for them to really consider what options they're going to take at that time.
Understood. And one of the things, and maybe hopefully I'm not as out of line. I mean, maybe I'm not out of line. I don't know. But if the family liaison program is working the way it shouldn't even matter that the cause and manner of death are pending for, let's say, 8 to 10 months. One would hope that the family liaison is communicating with the families during the process to let them know this or that, what the status is. So I don't know if that answers the question, but that's the best we can do. As far as an average, look, I don't see how I'm going to be able to give you an average of how long it takes. I think we listen to the family members and then we get the feedback from the department if we ask the department. But, maybe there's a way for us to look at the completed investigations that we've been getting from the department and kind of report back to you how long it's taken from the date of death to the date that we received the criminal investigation completed from them, and then average it that way. It's something that we can look at, providing that data to you.
Vice Chair Pintar.
I just wanted to clarify that I think Mr. Parker stated it, but to be sure, nothing prohibits anyone from filing a claim or a case with CLERB, regardless of whether or not they have an autopsy report or other investigative reports from the department. Is that correct, Mr. Parker?
Yes, that is correct.
Okay.
I'm answering for you, but you are correct.
Don't. I didn't hear the question.
So all we're talking about here, and if there's an investigation that's ongoing, there's no limitation or time limitation into how long it might take, is my understanding. It's just, we're simply talking about the amount of time within which a person can file a claim or a case or a complaint, rather, with CLERB. So 3 years after the incident. And I don't think it matters whether or not any of the other investigative reports have been turned over to the family. Is my understanding.
Just for clarity, though, we do have to, there is a time frame for us to complete the reports as well. And so this would lengthen that period of time. Ms. Kank?
Well, I have a question. I think. That's okay. That's okay. So if the family doesn't receive the autopsy report and they're not notified, within a certain period of time, how does that impact our investigation into the death?
Okay, that's a great question. To be clear, I want to make sure that we're all clear here. As far as a death, someone dies in custody, one would think that the department would notify us. So automatically we already know that information right then and there. Okay. Everything's going to kind of sort of stop until we until we get that information from the department. I mean, we have our own independent stuff that we do based on the MOU that we signed. There are things that we can begin to do. To your point about what happens to our investigation without an autopsy report. For example, we had a case just 2 months ago where had we moved forward, we had materials. Had we moved forward without the autopsy report, which would be ludicrous to do because we really don't know what the cause of manner of death is, it turned out that it was ruled a homicide, right? Which we never would have known until that came out. So we're kind of stuck without the cause and manner of death and the autopsy investigative and toxicology reports.
But do we get the autopsy report before the family gets the autopsy report?
Can't speak to that.
Okay.
I can tell you that what we get is the same redacted report. We get a redacted report. We don't even get the whole thing. We only get some things are redacted. The department gets the whole report because they're the investigating agency. But I believe we get the same redacted information that the family gets.
One thing we need to remember too is that a complaint does not need to be filed for death, for great bodily injury, and for other circumstances. So we're sort of mostly talking about complaints that would be filed for other things when somebody's incarcerated or
That
other.
That's exactly correct. That's what council was making sure I was on point about.
Okay.
Because, and so I don't know, I'm what council is saying is because it's a death, it doesn't matter. The 1-year time limit doesn't matter. So this would alleviate all the concerns that we're hearing right now about deaths. And so I'm going to defer to council on that. And so that should hopefully help the folks in the audience and on the call. When it comes to deaths, at least, there is no time limit to file.
Can you guys hear me? My name's Deanna Serna. I'm the sister of Elisa Serna. It's been 4 years. We don't have a liaison. We have never got one. So.
Writing a note there. So thank you.
And liaisons are lieutenants. As somebody who has had lieutenant.
Okay. Well, that's something that we can
Look into that.
look into that. Yeah. All right. Back to what we were talking. Did you have a question? Yes.
My question was actually the same thing as what Paul was just saying, that there's no statute. I was looking at, there's no statute of limitations on death in California statutes. The California statute of limitation, so we can investigate further.
Yeah. So just so we have clarity here, deaths, great bodily injury and other circumstances are automatically referred to us. Okay, with that, are there any other questions? I'm going to go back to Mr. Hayes then. Can you reiterate what you came up with? And then if we have a motion?
Yep. So
Okay.
after all this discussion, A through E, 5 years, F through H, 3 years. I'm making a motion. Oh, and is that that would be what, 5 years? Because it's not really itemized as A through H, so I don't. The additional one. Yeah, that would go under 5. Mhm.
Okay, 5 years. Is there a second?
I'll second. Well, or
Okay. Okay, any other discussion?
The last
Can you
thing.
please repeat the motion?
Oh, yes, Miss Vice Chair Bintar. Yes, could you?
Yes, I will repeat the motion.
Repeat the motion.
So I move that I'm trying to word the motion, so give me 1 second. I just wanted to make sense of what we're doing because we're talking about
It's okay.
a lot of stuff.
Take your time.
Well, I guess I move that we have a 5-year investigation
Time limit.
time limit on items A through E and the complaints involving allegations of great bodily injury arising out of or in connection with actions of a peace officer or custodial officer. And a 3-year investigation time limit on items F through H.
Okay. GI, Mr. Wilson, did you?
Just a point of clarification, the time limits that are currently in the proposed rules, they're not time limits for the investigation, they're time limits to receive a complaint.
Then
Just
that
wanna-
that is that's what
Okay,
and that's the intent.
Receive
Yes.
yeah, that'll be
Receive the
part of the
complaint.
motion.
Yes, that is part of the,
Okay.
receive the complaint,
Okay,
5 years, A through E, and
a 3-year.
3-year
Receive the complaint for
for
F.
F through H.
Okay. All right.
No. I had a question because I thought Paul said something about a I.
He was talking about
After-
great bodily injury.
Yeah.
Yes.
Okay, gotcha.
Yeah.
I mentioned I threw I out there because I confused the terms.
Yeah.
And but it that moves to the 5-year column.
Okay, thank you.
Okay. Any other discuss, we have a motion, we have a second, any other discussion? All right, could we have roll call, Pastor Spriggs?
Yes. Eileen Delaney,
Yes.
Mary Ann Pintar.
Yes.
Is she here?
And Vice Chair Pinkar,
You're
you were
muted.
muted.
Oh, sorry, I thought it was unmuted. Yes.
Okay. Pastor Robert Spriggs Jr., yes. Andrew Hayes.
Yes.
Dr. Arlie Brown.
Yes.
Nadia King Ayub. Bonnie Kink.
Yes.
Ariana Frederico Mondragon.
Yes.
And Mr. G.I. Wilson.
Yes.
Thank you.
Okay, motion carries. Thank you, everyone. Next would be board member comments. After that, does anyone have a comment? Okay, we'll move on to sheriff and probation liaison queries. Any questions? And there's our new lieutenant. Welcome.
Good afternoon. I don't know if this is on, but good afternoon, Sergeant Tingley with the San Diego Sheriff's Department at DIS. Just wanted to go over a few things that Paul already did. We do have 10 outstanding policy recommendations that we're currently working on. I checked on those today. We are currently working on those and we'll get those to you as soon as possible. I also have 2 outstanding sustained letters to provide Paul as soon as that information comes forward. I will hopefully have those in and done by the next meeting. I wanted to touch a little bit on the family liaison. We do have a strong family liaison program. If someone isn't being contacted by our family liaison, please reach out to Paul Parker or myself if you're in the audience. I would love to take your information so that we can rectify that problem if it is a problem. All of our family liaisons are working with families of all the deceased members. And if they're not, then we definitely want to know. So just let us know, reach out to Paul or I so that we can rectify that and get that problem fixed, because we definitely want family members to be reached by our liaisons. I also wanted to touch base on the medical examiner's report. We do provide CLERB with the full medical examiner's report that's unredacted. That's the Sheriff's Department. We do provide that within all of the reports that we provide CLERB. CLERB may not get that from the medical examiner's office, but he does get that from us. I provide that to Mr. Parker through the liaison with the San Diego Sheriff's Department. With that said, I don't have anything further other than introducing our new boss of the Divisional Inspectional Services, which is Lieutenant Dave Perkins.
Hi, everyone. Does this mic work or you can hear? Okay. Hi, I just wanted to come up and introduce myself so y'all know who I am and what I'm about. For those of you that don't know, I'm the lieutenant of the Division of Inspectional Services. We cover a lot of different things for the department, including assessing internal processes, reviewing high-risk incidents, and we also have the CLERB liaison out of my unit, who is Sergeant Tingley, as you know. Just a little bit about myself. I've been in law enforcement for 22 years. I've had a privileged career where I could work pretty much everywhere, in the department. I've worked all 3 bureaus we have to offer, including the Corrections Bureau, the Court Services Bureau, as well as the Law Enforcement Bureau. I spent the vast majority of my time in the Law Enforcement Bureau, so that's where most of my background comes in, is working on the streets. But I do have a lot of respect for the men and women that work in the jails and courthouse, because I know it's definitely a lot going on in there. Pretty much we've done, a lot of things that you folks can think of, including patrol, community-oriented policing, the psychological emergency response team, for those of you aware of that, also known as PERT, training, traffic, as well as our alternative custody program, known as CPAC. I've worked pretty much everywhere in the county you can think of. I spent most of my patrol career in North County, working in San Marcos, unincorporated Escondido, Vista, as well as the North Coastal Station, where Encinitas, Solana Beach, and Del Mar is. And then just recently, I came to Division of Special Services from the Rancho San Diego Station, which services Rancho San Diego, Spring Valley, Paso de Oro, Mount Helix, all those areas. I am familiar with CLERB, luckily. 3 of my years as a sergeant, I was assigned as the CLERB liaison. So I did work with CLERB quite a bit. And so I definitely know what your organization is about. I have a lot of respect for your service and for your mission. And I'm going to do my best in my power to work with you to get you, the information you need to fulfill your mission. Thank you.
Sir, thank you. And we know that the majority of the deputies and stuff do an excellent job. At CLERB, we're primarily concerned with the few who don't. So we don't mean to make, suggest that all the department, the entire sheriff department is a challenge. We mean those people who don't do the job properly. I hope you all know that. I hope I'm speaking for the group here. We're talking about the ones that things fall through the crack and they should have done a better job. Okay.
Thank you for that,
Thank
sir.
you.
And I absolutely agree with you. And I too have a problem with deputies that aren't, doing what they should. And I appreciate that. And you're welcome.
And thank you appreciate it. Thank you.
Thank you.
Yeah, if that was a motion, I'd second it.
Also, there is somebody in the audience that has some concerns about the liaison. And if you want to talk to Paul afterwards, if you're not comfortable talking with the lieutenant or sergeant, Mr. Parker would be happy to work with you. Council, can you read us into closed session? We'll meet back here in about 5 minutes.
Pursuant to Government Code Section 54957, this board will adjourn to closed session to consider items 11A and B on tonight's agenda.
Thank you. And thank you, public, for attending.